Recording started, you can start now.
Okay. So good morning, one and all, and now I'll welcome you all to the another session of company laws. Yesterday we were discussing about auditors, and before auditors, I had discussed about the managing director, that who can be a managing director, and we have seen that a person who falls under the category of executive directors. So executive director is a managing director because he is the person who is in charge of the day-to-day administration of the company. And because he has to take care of the company under the superintendence and control of other board of directors, and he will be appointed to take care of the company's affairs on the daily basis. So you can call him as a full-time employee also. Then we have seen that what are the disqualification of being an MD, and how the MD is appointed, maybe by an agreement of the company he will be appointed, or might be because of the clause which is mentioned in the article of association or any resolution passed by the board of directors. So these are the different ways in which the MD will be appointed. After MD, I had discussed in the session about the another important person of the company, and that person is known as an auditor. As we had discussed in the last lecture, that auditors are essential, they are important because they are aware of the financial transaction of the company. And we have seen that there are a number of duties which the auditor has to take care. He has to check the books of accounts. He has to take care of the balance sheet. He has to report to the members of the company in case of any discrepancy in the accounts. And there are a number of duties which the auditor has to perform. Apart from that, we had seen that who may become an auditor in a company. Then auditor is a person who must hold a practicing CA certificate under the Chartered Accountant Act 1949. And that is a qualification of becoming an auditor. One more important thing we had discussed about the rotation of auditors, and before rotation I had discussed about how you are going to appoint the auditor in the company. So we have seen that auditors are appointed, the first auditor is appointed by BOD, and in case if they fails, then they have to inform the members of the company, and the members will appoint the auditor. And in case of government company, the CAG will appoint. If he fails to appoint, then the directors will appoint. And if the directors also fails to appoint, then again the responsibility falls on members of the company and they will appoint. The most important part after the amendment of 2013 company law was that now the auditors are not appointed forever. And we had discussed this as in the form of rotation of auditors. If you remember, I had discussed that individual auditor, maybe if you are appointing an individual auditor, or if maybe you are appointing a team of auditor, okay, the audit firm. So if you are appointing an individual auditor, then it is easy because the person can hold the office for a period of 5 years. And if you are appointing an audit team, that means an audit firm, then the firm will hold the office for a period of 5 consecutive years for 2 terms. For 2 terms means for 10 years. After that, the individual has to be removed, the audit firm has to be removed, and we had discussed about the cooling off period also. What does it mean? That after a period of 5 years, the auditor who was appointed for 5 years, he has to go and join the another company, and he cannot continue in the same company for the next 5 years. In the same manner, the audit firm will continue to operate for the period of 10 years, that is 5 consecutive years for a period of 2 terms of 5 consecutive years. And after that, again, they have to take a cooling off period of 5 years. So that much we had discussed about auditors. I told you you have to learn about the duties of the auditors, powers of the auditor. At least you may learn 10 powers and duties, that are more than enough. Then we had discussed about the removal of an auditor also. So we have seen that you can, the auditor may be removed by the company also, but before that, the company has to pass, the board of directors has to pass a resolution, and after that, they have to take the permission of central government. for the removal. And before removing the auditor, they have to give the opportunity of being heard. So you have to provide a reasonable opportunity of hearing to the concerned auditor. He will come to the board of directors, and then he will try to prove himself innocent. And if he proves to do so, then okay, he will continue to do so. Otherwise, he will be removed before the expiry of his term. Secondly, we have seen that he may resign also. This is very easy because anybody can resign for the future prospect. And if he wants to resign, he has to inform the registrar of the company. And he will be removed by in certain circumstances if he had involved himself into some fraudulent activities, maybe pass on the financial information, which is a very confidential information of the company, to the different company members, or maybe he has done something which is not in favor of the company, then he will be removed by the tribunal also. But you have to remember one thing, that if he is removed by the tribunal, that is in the form of a penalty. Penalty means the punishment. Now, he will be punished by the court of law. So that is not good for any auditor, because definitely they will not get a job in any company. Because once you are in the eyes of law and you will be punished by the law, then nobody is going to hire you for their organization. So that much we have seen. So we have talked about auditors, and one more person is there, which is also very important in the company. Now, who is that person that I am going to discuss today? That person is a company secretary. Now, company secretary is also very, very important of person of a company, and he is also a important person. Why he is an important person? Because he has to take care of all the legal aspects in a company. Legal aspect means that he has to take care of everything which is connected to law. You can call in the layman's language corporate governance also, that he has to take care of that. He has to take care of that, for which objective the company was incorporated, and all the laws which are applicable on that company. Is the company following all the laws? That is his job, because he is a person who is having a legal background, who knows everything about laws, and that is a major responsibility on the shoulder of a company secretary, that you have to complete, you have to take care of all the laws which are applicable on your company. Now, what type of company you are having, that's a different thing, because all the laws are not applicable on each and every company. On the basis of your objectives, which company you are running, maybe you are running an IT company, you are running a leather business, you are running a glass business, or maybe a wooden or iron, whatever it is. Okay. In the same manner, maybe you are a manufacturing company, you manufacture something, the laws are different. So he is a person who is in charge of taking care of all the laws. He has to take care of that company is doing everything legally, and the company is performing all the legal duties as prescribed under the different types of laws. That is his responsibility. Now, coming to that, how and what is the definition of this person? So Companies Act 2013 defines that a company secretary means a company secretary as defined under section 21 subsection C of the Company Secretaries Act 1980. So what they are saying, they are not defining as such, they are saying under the Company Secretary Act 1980, whatever is the definition, the same definition we have to take it here. Now, who can be a company secretary? A company secretary needs to be a member of the Institute of Company Secretaries of India. Now, yesterday we had seen that who can be a auditor in a company. So if you remember, an auditor is a person who must have a valid certificate of practice, okay, under the Chartered Accountant Act. That is his eligibility criteria. In the same manner, a person who is going to become the company secretary, who is that person? That person must be a member of Institute of Company Secretary of India. Otherwise, he is not eligible. Okay. So they are saying that then only he or she is eligible to be appointed as company secretary of any company. So you have to remember that who can be a company secretary in a company. So your answer is only one line: a member of Institute of Company Secretary of India. That will be your answer. The Institute of Company Secretary of India is a body that regulates and maintains the profession of company secretaries. So this is an institute, and what is the working of this institute? They are saying that it regulates and maintains the profession of company secretary. So if you want to become a company secretary, then you have to join this institute. Then only you will get a certificate from there, and you will become a person who is eligible to be appointed as a company secretary of the company. Now, as said earlier, a company secretary is entrusted with the compliance and legal aspect of the company. So as I told you that what type of person he is? He is a person who is responsible for the legal aspect of the company. So auditor is also very important, but he is not taking care of legal aspect. What he is taking care of? He is taking care of all the financial aspects. So you have to remember, because both the persons are very important for the company, and but their profile is different. Auditor's profile is to take care of the financial aspect. Company secretary profile is to take care of the legal aspect. So these two words you have to remember. Auditor, you have to just take it as financial person. Company secretary, you have to take it as a legal person. So company secretary is appointed because definitely you are running the company into a legal sense. You have incorporated the company with the legal procedure as prescribed under the company laws. Then there are n number of laws which are made by parliament and which are applicable on your company. So if you are not going to follow those laws, definitely you will be in a legal trouble. Or might be somebody is doing something against the law in the company, then also this person has to keep an eye on everything, that everybody, whatever we are doing in the company, even a very small thing, he has to check whether it is connected with law, whether we are obeying all the laws, whether we are fulfilling all the terms and conditions, whatever things legally to be submitted to the registrar have been submitted, or are we submitting on time, that he has to take care of. So you have to remember that he is a person who is in charge of all the legal aspects of the company. Now, in which type of companies it is necessary to appoint this person who is known as company secretary? That means what type of companies it is compulsory that you must appoint a company secretary. Section 203 of Companies Act 2013 states that the following companies need to appoint a whole-time company secretary. That means following companies need to appoint. That means it is mandatory to appoint. There is no choice whether you are going to appoint or not. You don't have any choice. You have to appoint by default. Okay, so you have to understand in this manner that in the following types of companies, company secretaries has to be appointed, and it is compulsory under the law. Okay, first is all listed company. So if your company is listed company, then it is compulsory for you to appoint a whole-time company secretary. If your company is a public company, but having a paid up share capital of 10 crore or more, that means if your public company is, you are having a public company and the paid up share capital of a company is rupees 10 crore or more, what is necessary? What is mandatory? A whole time company secretary appointment is compulsory. And every private company having a paid up share capital of 10 crores or more. So you should understand that there are three types of companies in which it is mandatory to appoint the whole-time company secretary. And what are those types of companies? First is all the listed company. Second, a public company having a paid up share capital of 10 crore rupees or more. And every private company having a paid up share capital of 10 crores or more rupees. That you have to understand. This is a mandatory requirement as per section 203 of Companies Act. So you have to remember this also. Now coming to the roles and responsibilities. So as discussed, this person is responsible for legal aspect of the company. Everything which is connected to law, anything which is connected to law, he has to take care. Maybe if there is a, you can say, inspection of your company, okay, and the persons from outside, they are coming, the government officials are coming, okay, then this person has to be with them, and that person has to make a presentation, that this person has to present all the books, all the necessary documents, whatever are required for verification purpose. So he has to take charge of that verification process, and he has to be with those persons, those officers of the government, because they are there in the company to inspect the company. Sometimes the government officers come to check whether you are running a company in the legal form or not, or whether you are following and obeying all the laws whichever are needed or required. Okay, so what are the roles and responsibilities? Here are some of the roles and responsibilities, but you can find n numbers of roles and responsibilities to ensure the compliance of the provisions of various laws applicable to the company. So as I had said, that he is a person who is responsible for legal aspect. So the first responsibility itself says that he has to ensure that all the laws which are applicable to the company are taken care of. That means you have to take care of the laws whatever are applicable. So first of all, he has to find it out what laws are applicable. Then he has to check whether the laws whatever are following, or whatever the laws which are applicable on the company, is the company following those laws? If yes, then it is good. Okay, so he has to take care of all the laws, and he has to take care whether the company is following or not. There are two things. One is law is applicable on your company. Okay, second thing is whether your company is following the law or not. So applicability is automatic. Once you open the company, you will get the certificate of registration. Immediately the laws are applicable. Nobody will come to you and say that these are the law which are applicable on your company. It is understood that these laws are applicable on my company because I'm having this type of company. Okay, then if the company is, if the company is following the laws or not, that is a different thing. Whether your company is following the laws or not, that is the different thing. Laws are applicable. It is, of course, it is understood that the laws are applicable because you have incorporated the company. Okay, but whether the company is following, because some companies are there, those who are not following the laws. And if definitely if somebody will come and verify, then they have to be in a legal trouble. So what is that? Which is what is essential? The essential part is whether you are following the laws or not. Then next is to ensure the affairs of the company are conducted in the manner specified in the memorandum and article of association of the company. So if you remember, we have discussed that memorandum and article of association of the company are two important documents which you have to submit at the time of registration of the company. Registration. Now you have understood what is the meaning of registration in the legal form, incorporation of the company. So when you have sent the documents to the registrar for incorporation, you have sent these two documents. Okay. All the things are mentioned in memorandum because it is a charter of the company. Article of association, it is an internal document which is which talks about the internal management of the company. So he also has to check whether the company is running as per the memorandum and article. This is also his responsibility and his duty, that whether whatever we have mentioned in the article of association, whatever we have mentioned in the memorandum of association, is the company following everything as per the memorandum and article of association of the company? Okay, this is also his duty and it's a part of his responsibility. Then to conduct the board meetings, committee meetings, general meeting, and to attend the same. Now, in the company, there are different types of meetings. Okay, what he has to do, he is in charge of all the meetings. So what he has to do, he has to organize all the meetings, whether they are the meetings, committee meetings, board meetings, general meetings, whatever types of meetings are there. He is a person who is in charge of conducting those meetings. And one more thing, apart from conducting, he has to be present also. So not only conducting part, I am not going to conduct only and then I will leave the meeting or I will not attend. No, it is mandatory for the company secretary to attend all the meetings also, apart from organizing the meetings. Then to advise the board of directors of their legal obligation. Again, again and again, I'm discussing the same thing, which you have to remember that this person is in charge of what? He is in charge of legal aspect. So for example, if the board of directors are having any legal obligation on them, that means some legal duty is on the shoulders of the directors, that means BOD, but BOD is not obeying that duty. That meaning is they are not fulfilling their legal duties. So it is the responsibility of the company secretary to go there and make them realize that, sir, this is your legal duty. You have to fulfill this duty and please kindly fulfill the same. So this is his responsibility to make them realize that they are not fulfilling their legal duties, they are not obeying their legal duties, and they have to do it because he is in charge of every aspect of legality. Next is to represent the company in front of various regulators and government departments. This I had already discussed that, for example, if there is a verification in the company and the government officials are coming or any other regulator is coming to the company to check the company, what you are doing, how you are doing, and what type of business you are doing, whether you are doing the business as for the objectives which you have mentioned in the memorandum of association. Okay, so they have to check. Now, government officers are coming. Maybe somebody from Ministry of Corporate Affairs. They would like to see your company. They want to visit the company and inspect what you are doing and how you are doing. So, who is going to take care of their visit? The company secretary, because only he knows in the company what is law. He knows what type of laws we are following. If there is any question maybe asked by the regulators or asked by the government officers, that sir, you are not following this law, why you are not following? So he must be ready with the answer that sir, this is the reason why we are not following, and these are the reasons this law is not applicable on us. So he has to make it clear and he has to give the clear answer to them. Okay, so he is in charge of attending the meetings, he is in charge of conducting the meeting, he is in charge of realizing to the board of directors that they are not fulfilling their legal duties, he is in charge of taking care of all the visits which are made by regulators and government departments of the company. Okay, so this much you have to learn in company secretary, that what is the meaning, who can be a company secretary, then in what type of companies the company secretary responsibility and the appointment is mandatory. So mandatory may we have seen that if you are having a listed company, if you are having a company which is a public company but paid up share capital is 10 crore rupees or more, and if you are having a private company but the paid up share capital is 10 crore or more. Okay, so this much you have to remember, and at least not more than 5, I think, responsibilities or duties you can write. Even if you write in your own language, then it is also okay, because you have to just say in different ways that he has to attend the meeting, he is in charge of conducting the meeting, he is in charge of taking care of legal aspects of the company, he has to take care of the government visits, whatever are going to happen in the company. Okay. So this is all about the chapter which is companies management. Now we are moving ahead with towards the different chapters. So I'll stop sharing here and again I will share the another PPT. Yes, please. I hope my screen is visible to you. This is the another chapter, and this chapter is about companies meeting. Okay, so we have just ended with the companies management. Companies management we have just ended with the company secretary, roles and responsibilities of company secretaries in the company. Now we are going to begin with a new chapter, which is companies meeting. This is also a very, very important chapter because companies meeting has to be conducted in the legal criteria, in the form how they are mentioned to be conducted under the Companies Act. And if you have not conducted the meeting as per the law, then that meeting is no more be a valid meeting and it will not be considered as a meeting. Okay, so you have to be very careful as far as legal rules and regulations are concerned for the meeting, because if the person who is in charge of conducting the meeting, the person has forgotten some of the provision, might be one or two provision he or she missed out, or maybe they have forgotten, then the meeting cannot be considered as a valid meeting. Again, you have to begin with the new meeting. You have to do everything, whatever I'm going to discuss now in this session, that how you can say that your meeting is a valid meeting. Because if it is a void meeting, void means which is not having a value in the eyes of law, then it is of no use of conducting the meeting. So if you have not conducted the meeting in the valid manner or the legal manner, the meeting is not considered to be taken place as per law, and that will become a void meeting. So before moving ahead to the different types of provisions of a valid meeting, first of all, we will see that what is the meaning of meeting. Okay, so a company meetings means two or more individuals coming together to carry out a legitimate business or to take decisions on the same. What they are doing? They are saying that two or more persons, generally when in the layman's language, as per your understanding, what do you understand by a meeting? Definitely you will say that two or more persons meet with each other and they discuss something. That is a simple answer with any which anybody can give. Okay, so simple answer that a company's meeting, meeting means, first of all, a meeting means that two or more individuals discuss upon something, any topic. You may say any topic, discuss upon something. So when we talk about the company's meeting, definitely we are talking about a meeting in which you are going to discuss some business, because we are talking about not only meeting, we are talking about company meeting. So company meeting, we are going to discuss something which is a business, and a business, they have used the word legitimate. That means in the meeting, it is compulsory you are going to discuss only legal thing. That means legal meeting, legal business, you are not allowed to discuss anything which is illegal or which does not falls under the purview of law. If you are doing this, it is not a company meeting. It may be a meeting, it may be a personal meeting, it may be a friend's meeting, it may be anybody's meeting, but it is not a company meeting, because company meeting is restricted to the business which you are doing under a company, and it is also restricted to the legitimacy part. That means the business which you are discussing in the meeting, it has to be a legal business only. So you are not allowed to any illegal business in the company's meeting. Okay. You, in other words, you can also say that assembly or a gathering of people to for some business transaction which is legal. Now see, again and again they are using the word which is legal. So they have used the word legitimate, means legal. They have used the word legal, that means as per the law. Gathering of people, people maybe n number of peoples, but more than two, because one person cannot hold a meeting. So more than two persons are coming together to discuss some business transaction which is a legal business. One more definition is there. A meeting may be generally defined as a gathering or assembly or getting together of a number of persons for transacting any lawful business. So if you see, all the definitions are saying the same language. Okay, they are saying the same meaning. That what do you mean by meeting? They are saying gathering of people, assembly of people, coming togetherness of people. And what is the reason of coming together, gathering, or assembling? The reason is to conduct some business. And what type of business? It should be a lawful business, legitimate business, or a legal business. Okay, so the definition of the company, you can write again in your own words. Also you can write that in simple words. You can write that it is a meeting of persons, the persons, or maybe assembly of persons or gathering of persons who are coming together to discuss some business which has to be legal. In this manner you can also write the definition. Okay, now we will start with different types of companies meeting. So how the companies meeting, what type of companies meetings are there, and how many meetings are there. Now, types of meetings, it is also very important. So beginning with first type of meeting, which is known as shareholders meeting. Now, shareholders meeting, again divided into three parts: annual general meeting, extraordinary general meeting, and class meeting. Okay, so these all are the types of different types of shareholders meeting. Shareholders meeting may be divided into three parts: annual general meeting, extraordinary general meeting, and class meeting. Now, what is annual general meeting? With the name itself, it suggests that it happens only once in a year. Annual, because that's why the name is annual. Annually, only once in a year. Once in a year, the shareholder will come together. They discuss about the legality of business. Maybe they discuss about the expansion of business. Maybe some of the parts they want to remove. They want to stop some of the productions. Maybe some items they don't want to produce more. Some new production they will start, or they want to add something new. Anything they can do for the betterment of the company and for the future of the company. Definitely, it will result into profit. profitability, then only they will do this. Okay. So annual general meeting, you have to remember, as the name itself suggests, it will happen once in a year, and it is a shareholders meeting. All the shareholders come to one place, designated place, whatever is informed to them by the company that this is a place of meeting, this is the location, you have to join here. So everybody will join there. Now coming to extraordinary general meeting. Now what it is? Extraordinary general meeting will happen when there are some emergency. Maybe there is some emergency in the company, and you cannot wait till the period of annual general meeting, because annual general meeting will happen once in a year. So I cannot wait for one more year. For example, in the month of maybe May, we have conducted the annual general meeting. Now again, when we are going to conduct, definitely next year 2025. But I have to discuss something which is very, very important. There is an emergency in the company. Emergency circumstances are there, and I need to call a meeting. It is compulsory. I need to call a meeting. Then what type of meeting I need to call? I need to call an extraordinary general meeting, because there are certain circumstances in which I cannot wait till next year to call the annual general meeting, because it will happen only once in a year. And that we had already conducted in the month of May. So again, in the month of July, we cannot have the meeting. So the question is, if there is emergency circumstances and it is necessary to call all the shareholders of the company, that what type of meeting we have to call? We have to call extraordinary general meeting. It may be, you can remember in this form, that extraordinary general meeting will happen between two annual general meetings. This is also a way of learning the definition of EGM. That EGM will happen between two annual general meetings, or in other words, a meeting which took place between two annual general meetings is called EGM, extraordinary general meeting. Okay, in this way you can also learn. If a meeting took place between two annual general meeting, what it is called? It is called extraordinary general meeting. And you have to remember, in the easy language, why it need to be called? It need to be called because there are some emergency circumstances in the company. Now the third one is, it is also a shareholders meeting, and it is known as a class meeting. Class meeting, you know that the shareholders of any company are divided into two parts as per the shares which they have bought. And the shares are also of two kinds, preference shares and equity shares. In the same manners, the shareholders are also either preference shareholders or equity shareholders. So for example, the company is interested in calling the meeting of preference shareholders only. That is known as class meeting, because you are inviting a specific class of shareholders to the meeting. Okay, you are inviting only preference shareholders, might be, or maybe you are inviting only equity shareholders. So because now I'm not calling all. In the annual general meeting, you are calling all. In the extraordinary general meeting, you are calling all. But in the class meeting, I have divided the two types of shareholders into different classes. One class of shares are preference shareholders. Another class of shares are equity shareholders. And I am going to call the meeting for equity shareholders only. So that is known as class meeting, when you are inviting only a specific class of shareholders to attend the meeting. Now coming to the second part, that is the board meeting. Now board meeting is very easy, because we have already finished our company's management chapter. You have already learned that directors are appointed for company's management, and we had discussed different types of directors also. So whenever they are organizing a meeting, okay, so BOD meeting. Meeting is board of directors meetings, or you may in short say board meetings. So board of meetings is board of directors meetings. Then meeting of the committees of the board. Now there are n number of committees also which are created or constituted under the company law. For example, you can take remuneration committee, audit committee, or maybe CSR committee, corporate social responsibility committee, or you may have stakeholders committee. So these are different types of committee which has to be there in the company, and definitely the members of the committees against are the directors of the company. Okay, so Apart from the BOD meeting, they have to attend the committee meetings also, whatever committees are there, you have formed in the company. So whatever, I have given you the examples. Example is audit committee hai, CSR committee is there, maybe remuneration committee is there, stakeholders committee is there. Okay, so all the committees have on the board the different types of directors. Okay, different types of directors are the members of the committees, and they must also meet as per the legal requirements. They have to call the committee meetings, that is known as meetings of the committees of the boards. Next is meetings of debenture holders. Now, what are they? Debenture holders, if you know who are the debenture holders. Debenture holders are the persons, those who have given long-term loan to the company. Okay, so for example, Mr. X have given loan to the company XYZ Limited for a period of 20 years. Okay, so he will become the debenture holder of a company. Now there are n number of debenture holders in a company, and the company would like to meet all the debenture holders. Then what they will do? They will call the meeting, and in that meeting, they will call only the debenture holders. Only the debenture holders are allowed to attend the meeting. So if they have called all the debenture holders to attend the meeting, that is known as meeting of debenture holders. Next is meeting of creditors. Now, creditors, if you know who are the creditors, creditors are also the persons, those who have given loan to the company. Maybe it's a short-term loan, maybe it's a long loan also, a small amount of loan also, big amount of loan also, but they are the creditors of the company. And the company wants to call a meeting in which they would like to invite only the creditors of the company. So maybe, for example, in a company, we have 100 creditors. Okay, the company would like to call them. They want to discuss something. Maybe they want to ask for some more loan, or they want to repay the loan, or maybe they want to say something just to keep them happy because they are the creditors. They have given the loan to the company. So if the company is inviting the creditors to attend the meeting, what it is? It is the creditors meeting or meetings of the creditors. Next is meetings of contributories in winding up. Now, who are the contributories? Contributories are the persons, those who have promised the company that in case of winding up of the company, winding up means when the company comes to an end. So they are going to contribute towards the assets of the company. Okay, they have given some amount, guarantee, some amount they have promised to the company that when we are going to close the company, and if there is a lack of money in the company, because naturally the company closes at the time when the company starts suffering losses and we don't have money. So if the company is having the losses, they don't have a money, then what it is? They will say, okay, now we don't have money and we have to shut down the company. Then we have to call the contributories meeting because they have already promised that they are going to contribute to the assets of the company. Okay, in that circumstances, so this meeting will be called only in case of winding up. Winding up means the closure of the company, when you are going to shut down the company, when you have started the legal process of closing the company. Why legal process? Because you have incorporated the company with the help of law, and company is known as an artificial legal person. So you have to put the company's life to an end with the help of legal process only. You cannot shut down the company with your wish and will. You have to follow the process which is given under the company's laws 2013. Okay, then you will call the contributories meeting only in case of winding up. The other meetings, so definitely lifetime during the company you can call. You can call the committee meeting, you can call the debenture holder meeting, creditors meeting, board of directors meeting, but contributories meeting will come into picture only in case when the company goes into the winding up process. Okay, so these are the different types of companies which you have to remember when they will happen and who is invited in which type of company. The shareholders meeting, annual general, extraordinary and class, all are connected to shareholders. Shareholders are invited. In the board meetings, the board of directors are invited. In the committee meetings, the directors, those who are the members of different types of committees, they are invited. In the debenture holder meeting, only debenture holders are invited. In the creditors meeting, only the creditors are invited. And in the contributories meeting, only the contributories will be invited. But this meeting will happen when the company will go into winding up process. Okay, so this is all about the types of companies. Now moving ahead with the same chapter, this part is really very, very important. Okay, you have to understand it carefully because this is the only thing which you have to learn, and you have to understand that when your meeting will be said as a valid meeting. Because as I told you earlier, if you conduct a meeting and meeting is not as per law, then it is of no use. It will become void, and in the eyes of law, it will be assumed that the company has not conducted any meeting. But legally, you have to conduct the meeting as per the time given under the law. So all the meetings are called as per the law. It is not on my wish and will that whenever I want, I will call a meeting. The law has already specified the time for each type of meeting, and the person who is in charge of conducting the meeting, that person will see the time and will see that when he is going to call which type of meeting, because it is a legal requirement. You have to, because you are running the company under the law. So you have to follow the law. Meeting is also an important aspect which has to be conducted as per the time and schedule given. Okay. So the question is when you can say that your meeting is valid, or what are the essentials which makes your meeting a valid meeting. Okay, please pay attention here. Every meeting, in order to be valid, must be duly convened, legally constituted, and properly conducted. Now, this is the language which is given under the law, and it has all the essential elements of the meeting. What is the essential element? First essential element is the meeting. If you want to make it valid, it must be duly convened. This is the first number, duly convened. Okay. Second essential is it should be or it must be legally constituted. This is the second essential. Third is it must be properly conducted. So in in summary, there are three essentials of a valid meeting. What you have to understand, there are three essentials of a valid meeting. First is the meeting has to be duly convened. Second, the meeting has to be legally constituted. And the third important point is meeting has to be properly conducted. Now, starting with the first one. So I will start with the first one, and first essential is duly convened. Now, what are the important points which falls under the category of duly convened? First point is that meeting to be properly convened, the meeting must have been convened by proper authority. That the meaning is, if you are calling the meeting has to be called only by a proper authority. That means anybody can call the meeting. No, it is not allowed. Then it will not be valid. To make the meeting valid, the proper authority must call a meeting, and they have defined the proper authority also. What is the proper authority? They are saying the proper authority to convene the meetings are board of directors, shareholders, or tribunal. So what they are saying? First, to make your meeting valid, the meeting has to be duly convened. What is the meaning of duly convened? Duly convened, first meaning is that the meeting must be called by proper authority. Now the question is, who is a proper authority to call the meeting? Your answer is the board of directors, the shareholders, or the tribunal. Tribunal again means National Company Law Tribunal, NCLT. Okay. And what they want to say that to call a valid meeting, what you need to do, you need to give a proper and adequate notice to all those who are entitled to attend the meeting. So because you are calling the meeting, how you're going to call the meeting? How you're going to call the meeting? Definitely there is some way now to inform the people. There are 5,000 shareholders and you are calling a shareholder meeting. How you're going to call? You have to inform them. How you're going to inform? So law says you have to send a notice. Proper and adequate notice has to be sent to all the persons, those who are entitled to attend. Entitled to attend means those who are legally eligible to attend the meeting, to whom you have to send a notice. Notice should be proper and adequate. That means there are certain legal requirements in which you have to send a notice. Notice has to be designed in a format which is prescribed by law, which is prescribed by company law. Okay, so we will see that when and how the notice is also a legal notice. So first is proper authority. Proper authority is BOD, shareholders, tribunal. And how you are going to call? You have to call the people by sending the proper notice to all who are entitled to attend the meeting. Now, another essentials of a valid meeting is we are discussing about the meeting. So meeting may definitely you are saying that we are going to call the persons through the help of notice. So notice, how many days notice you have to serve? That's another question. So the answer is the company has to send a clear 21 days notice to its member to conduct the meeting. To conduct the meeting means to conduct the AGM, annual general meeting, to conduct the extraordinary general meeting. How many days notice you have to send? Because
मैम, आपकी
yes,
पीपीटी दिख नहीं रही है, एक बार आप शेयर कर दो ना फिर, फर्स्ट पेज सेकंड पेज
1
पीपीटी
minute.
मूव नहीं हो रही,
मूव नहीं हो रही।
फर्स्ट पेज ही दिखा रहे थे।
Now,
हाँ,
now
अभी
is
दिख
it
रहा है,
visible?
यस
Yes.
विजिबल।
Okay. So the company, because we had discussed in the previous slide, this is the previous slide. In this, we had discussed that the notice, proper notice has to be sent to all the persons, those who are likely to attend the meeting. Okay. So when you are saying that proper notice has to be sent, how many days notice? The legal requirement of a notice is days, number of days. Number of days they are saying the company has to send a clear 21 days notice to its member to conduct the meeting. And I was talking about that you have to send this 21 days notice for AGM and for EGM. Now, what the notice must say? So the notice or the notice must contain or the notice must mention. The notice must mention the day of the meeting, whatever day, Monday, Tuesday, Wednesday, whatever, the date of the meeting and the location of the meeting. These are the three essential things which you have to put in the notice, because as a shareholder, how will I come to know where I have to go for the meeting if you have not mentioned in the notice? So you have to tell me now that, ma'am, this is the location of the meeting, this is the conference room, you have to come to this, the address is so and so, the date is so and so, the day is so and the time is so and so. So you have to clearly mention everything in the notice, and you have to send this notice with the 21 days clear notice. They have mentioned 21 clear days notice you have to send. Now, when you are organizing a meeting, you have to put a time also, because you are giving me the day, you are giving me the location, but by what time I need to attend. Okay, so I have to come before 15 minutes before you start the meeting. I will join the meeting 15 minutes before. So I have to reach the location. Definitely it will take time. Maybe you are conducting the meeting in some different city or maybe in some different state. So I have to go to some city. I have to plan accordingly. I have to leave my office. I have to book the tickets. I have to plan to attend the meeting. So a number of things are there. Okay. So they are saying that a meeting can be conducted at any time, provided it is during the business hours. This is very, very important. You cannot call the meeting outside the business hour. Business hours is the word they have used here in the meeting chapter. And what do you mean by business hours? Business hours means between 9 a.m. to 6 p.m. This is the time which they have given. Now you can call the meeting between 1 to 3. You can call between 10 to 2. You can call between 11 to 3. You can call at any time, but it should be between 9 a.m. to 6 p.m. And the day of the meeting is not a national holiday. Now you must know that what are the national holidays which are available in our country. So you cannot call the meeting on 26th January or maybe, for example, 15th of August or maybe 2nd of October. These are all the national holidays. You cannot call the meeting, any meeting on this day. You can call on any day between 9 to 6. Apart from national holiday, you have to leave. Then it can be held either at any pre-decided place within the area of the jurisdiction of the registered office or at the registered office itself. Now, location also they are saying it should be legally defined. So location is also mentioned in the law, that where you need to call the meeting. You are deciding the day, you are deciding the date, you are deciding the location, you are deciding the time. Time they have already mentioned in law between 9 to 6. And location also they have said, either you can call the meeting at the registered office. So where your office is registered? Okay, there is a place, there is a city, maybe it is registered in any city of the country. You have to put that office address where you are going to call the meeting. Where you are going to call the meeting? You are going to call the meeting at the registered office. Or if you are not calling the meeting at the registered office, there is a reason why. For example, I am calling 5,000 shareholders to attend the annual general meeting. Okay. And 5,000 shareholders, it is impossible that all 5,000 shareholders are accompanied in my conference hall. Definitely in my company, the conference hall is not so big that it will accommodate 5,000 people at one point of time. So what is the legal requirement? Two legal requirements. One is either you can call at the registered office. Registered office, the conference hall is not so big. I cannot call 5,000. If this is a problem, then what you can do? You can arrange at some different location, but in the same city where your registered office is situated. So this you have to keep in mind because this is a legal provision. What they are saying, that what should be the location of the meeting when you want to conduct a valid meeting? Either you can call the meeting at the registered office. Okay, if you are not calling the meeting at the registered office, where you can call in the same city where your registered office is situated. This you have to keep in mind. Now moving ahead with the essentials of a valid meeting. The another essential requirement of a valid meeting or to make the meeting valid. So first of all, we have seen that first requirement is who may call a valid meeting, that we had already discussed. Now coming to the another part, notice of the meeting you are going to send to whom? That means who are entitled to receive this 21 clear days notice. Okay, so these are the persons who are entitled to receive. The heading says notice to be sent to whom? And the answer is notice of every meeting of the company must be sent to every member of the company, the legal representative of the deceased member, the assignee of an insolvent member, all the auditor of the company, and every director of the company. So these are the five different persons who are entitled to receive the notice of the meeting. Who are they? First is all the members. Every member you have to send by default. Okay, they have to attend. Then in case if your member is a deceased member, then you have to send it to the legal representative. Definitely that person must have some legal representative. You need to send the notice to legal representative. If the member is declared as insolvent, for example, because you know insolvent member is not entitled to sign anywhere as per law. Okay, so if the court declared a person as an insolvent person, but he is a member of some company, so he will not join the meeting. On his behalf, the notice will be served to his assignee, which is appointed by the court of law, and the assignee will receive the notice and he will attend the meeting on his behalf. All the auditors of the company, if you are having an auditor or maybe an audit firm, all are invited to the meeting. You have to send the notice to each of them, and every director of the company must attend the meeting. So this you have to remember. These are the five different people, those who are likely to attend the meeting, and the notice has to be served to all. It is a mandatory requirement. I repeat again, it is a mandatory requirement to that they will receive the notice. And if you miss out the notice, then you will be under a penalty. The law will impose a fine on the person of doing the mistake that he missed out any person who is entitled to receive the notice for the meeting. Okay, by default, you have to give. Now, when I'm saying that you have to send the notice to all the persons, those who are mentioned above, what is the mode of sending the notice? How you're going to send the notice? That means what is the mode? How you will send? So maybe you will send it by registered post. You will send it by speed post. You will send by courier also. Okay, these are the different modes which are mentioned in the law itself. For sending the notice, you may use the registered post, speed post, courier, and send it at the registered office. Then definitely every member has already given the registered office to the company. Every member, once you buy the share, all your details are in the computers of the company. Okay, in the data bank, that this is a shareholder, this person resides here, and this person name is there, Aadhaar card, PAN card, everything, every detail is there. So you have already given some address of your house. They will send the notice by registered post, speed post, or courier at your registered address. Or the most important and easy method these days, the electronic mail. That means you can send the notice by the mail also. So definitely, if I'm a shareholder in a company, I have submitted my name, my mobile number, and my mail ID. So what the company will do, the company will draft a notice and send it to me and saying that, ma'am, you have to attend the meeting. Kindly find a notice for the same. And the notice is there. And I will open the notice and every details are mentioned in the notice. I have to attend the notice as the designated place. So when you are sending the electronic mail. That is the easiest way of sending and delivering the notice. One more legality and legal point is here. If a member requests for the delivery of any document through a particular mode for which he shall pay such fees as may be determined by the company in its annual general meeting. So, for example, I am a member and my requirement is whenever the company organizes a meeting, the company will deliver the notice to me by registered post. So I am the individual person who is asking something which is definitely the company is going to send the notice by mail to all the members, to all the shareholders, correct? But one of the shareholder is asking for a specific mode and he wants that, sir, I don't check the mail and it is very impossible for me to check the mail because I'm busy with n number of things. Kindly send the registered post notice by registered post or by speed post to my address. So he is requiring something special from the company. What he needs to do? He has to pay the fees for that. So whatever is the fees, maybe 500 rupees or 1000 rupees of sending the notice by post to the registered address. So the company will determine a fees, the company will prescribe it, inform the member, and the member has to submit to the company's account because he is asking for something which is out of the way. I am sending, as a company person in charge of sending the notice, I am a person who is ready to send the notice by email. But you are asking me to serve the notice in a specific way, in some specific category. Then what I need to do? I need to charge you. So the company will determine the price. The company will ask that, okay, you will send the notice. We will send the notice definitely, but you have to pay the fees for the same. So this you have to remember. To whom the notice has to be served, who are the members, who are the persons, the authority who can call the meeting. That is very important. How many days notice you have to serve? That is very important. What you have to mention in the notice, the day, the date, the time should be the business hours, and what is the place. Place means the location. What is the location? The registered office of the company, or if you are not calling at the registered office, you need to arrange the meeting at any other place but in the city where your registered office is situated. And to whom the notice has to be sent, or in another word you can say, who is entitled to receive the notice? This is also the same question. Who is entitled to receive the notice? The same answer you have to write. All the members, the legal representative of a deceased member, the assignee of the insolvent member, auditors of the company, and all the directors of the company. And mode you have to remember, that is very easy. There are 3 to 4 types of modes: registered, post, speed post, courier, and electronic mail. Okay. But you have to remember one thing: once you are asking the company to do something new, something extraordinary for you, you have to pay the charges for the same. So I think I will stop here. And then I will discuss the remaining essential elements of the valid meeting in the next session, definitely. And hope you have enjoyed the session. And I will continue with the same in the next session. We are going to discuss with the same. The company's meeting is a chapter name. You can see your syllabus. I think it is a 4th unit. So company's meeting, you can find it out. And we are discussing right now the essentials of meeting. It is still remaining because it is a very long question. And there are n number of provisions which are going to make the meeting of the company legal and valid. So here I am going to stop. And thanks a lot for joining the session.
मैम आपका आवाज नहीं आ रहा है.
Yeah, sir, the session is over.
ओके मैम.
जी.